On Wednesday, February 11th, Hood River County Planning Commissioners made decisions on a number of issues relating to the appeal filed by Packer Orchards in regards to their request for changes into how their farm stand would be operated. You'll hear about what the final verdicts were on all of those issues, but the real points that came through were not only the nitty-gritty about individual versus bulk servings or how to define admission fees, but concerns about how family farms could continue operating. There's a tension between the difficulty in making a living these days from family farming, agritourism, and ways to support that.
It's been very challenging because there are two goods we're trying to achieve. We're trying to preserve farmland and we're trying to make sure that farmers can actually make a living on the farm. And those don't always coincide as goals that are mutually compatible.
One of the first issues being talked about was whether or not Packer Orchards would have to sell items in bulk, meaning they might be intended to be consumed off-site, or whether they could simply sell items in USDA packaging, no matter what the size, to consumers who were purchasing them there at the farm stand.
In this particular case, I struggled a lot with it because I can understand trying to regulate the distinction. But if you go back to the administrative rules, they only mention of foods that are excluded from farm products are prepared foods. They don't mention packaged foods. And so to me, it's a stretch to try to create that distinction or for what is a prepared food consumed on site versus off site. So in essence, I'm agreeing with Commissioner Garrick and our chairperson.
Commissioners voted unanimously to allow the packers to sell packaged items in USDA packaging. Oregon's renowned land use bill, Senate Bill 100, also came into play as Commissioner Ryland Moore discussed.
So Oregon's land use system, created under Senate Bill 100, was visionary. Goal 3 was designed to protect agricultural land from fragmentation and conversion. It's worked. Hood River County remains a productive agricultural landscape because of it. But the economic environment of agriculture in 2026 is not the same as it was in 1973. Land values are significantly higher, labor costs higher, regulatory compliance is more complex. Input costs, fertilizer, irrigation, equipment, insurance have all increased. The small family farm today operates in a far tighter margin environment than lawmakers could have anticipated 5 decades ago. If our regulatory framework does not evolve alongside these economic realities, then I believe we risk protecting land in theory while losing family farms in practice. Goal 3 protects farmland for farm use. It does not freeze farm business models in time, allowing carefully structured agritourism, admissions, pumpkin patches, and corn mazes, hay rides, modest playground areas, on-farm education, and the sale of goods produced and consumed on site or off-site does not convert farmland. It does not subdivide parcels. It does not rezone EFU land. When managed properly, it strengthens the agricultural enterprise that keeps that land in production. These activities are not a departure from agriculture. They are an extension of it. They connect the public to farming. They create local markets. They increase direct-to-consumer sales. They build community support for agricultural preservation. Most importantly, they provide revenue stability. Revenue stability is farmland protection policy, in my opinion. If small farms cannot generate sufficient income to offset rising costs, they do not simply disappear quietly. They consolidate, they sell, they create political pressure for alternative uses. Over time, economic fragility becomes land use pressure. Modernized approach to farm stand regulation can maintain clear guardrails. Agricultural production must remain dominant. High-value soils must remain in use. Permanent commercial infrastructure must be limited, and traffic incompatibility must be addressed. But within those guardrails, we should allow farms reasonable flexibility to adapt. Protecting farmland today means protecting farm viability. Protecting farm viability requires acknowledging that diversified agricultural-related income is part of modern farm survival. Senate Bill 100 was not intended to prevent adaptation. It was intended to prevent conversion. If farmland remains in production and family farms remain viable, then we are honoring both the letter and the spirit of Oregon's land use system. I look at the Packard Orchard appeal under this lens.
As of February 2026, Oregon law states that land in exclusive farm use zones is mainly for farming, and that income from events and retail sales cannot exceed 25% of the farm stand's total earnings.
Yes, B is particularly focused on how to address admission fees and other fee-based activity. And I don't remember whether it's ORS or an administrative rule, but it's very clear that admission fees are to be considered incidental. So I think the language as county staff have prepared regarding admission fees is appropriate. However, I would say to the appellant that a good bookkeeper could find ways to revise the way you sell products and fees to account for your concerns about not going over the top on your 25%. For example, you could have a two-tiered structure where you say you can buy an admission ticket for 25 bucks. Or if you come to our stand and buy $20 worth of goods, we'll give it to you for $4.99.
Yeah, I guess two different ways to approach it, right? I see the way our logic's doing the same thing. We're just thinking of it different ways. In some ways, it's much cleaner. You're right. It's much cleaner just to deny that portion of the appeal. I agree with that.
Okay.
I move that we deny the portion of the appellant's proposed language relating to how admission fees are accounted for, and continue to use the county language that was part of condition 3B.
Okay. You still want to second that? Yeah. Okay, it's been moved and seconded. Any other questions? Commissioner Loomis?
Aye.
Commissioner Moore?
Aye.
Commissioner Guisto?
Aye.
Commissioner Kitts? Commissioner Lyman?
Aye.
Commissioner Garrett?
Aye.
Chair votes yes also. Okay.
The last thing I'm going to share here is the discussion about playgrounds and the temporary play structures. Throughout the packet that contained all of the pro and con testimony about the Packer farm stand, some of the play activities and special event activities got frequent mentions. Some were described as being great ways to introduce kids to farming and farm activities, while other neighbors in the area were concerned about things like the boozy glow-in-the-dark egg hunt. Commissioners had to decide whether to accept the county planning department's suggestion that 90 days after this ruling, all temporary and permanent play structures would have to be removed. Here's what they ended up discussing and deciding.
What does this do towards taking farmland out of production or somehow going against goal 3? And I can't find anything specifically that's not built on high value soils. I think we all went out on a tour out there and saw how wet it was. There's a lot of educational stuff that's permanent structures that are out there. So I don't have a problem with those play structures, especially from an agritourism perspective and what they do for education.
Commissioner Guisto?
I agree with that. This is, a tough one. When you read the county's language versus the appellant's language, the Packers are trying to make some adjustments here by limiting the time they're using it from mid-September through October. Otherwise, customers may not otherwise have access to the play equipment. It's bringing kids out onto the farm. And sometimes you have to have the attractant to bring them there. A kid might not want to go see an apple tree, but if they get to they get to go on a swing, or they get to go on like a pretend tractor, and you get to do those fun things. And then you also get to look at, how the bees pollinate the trees. And unfortunately, to get kids involved in those types of things, sometimes you have to have the attractive feature. And with the limiting language and the limited use of the play structures, I don't have a problem with the play structures.
I understand that it's like really fun and It's a great activity for young kids and young parents. I do worry that become the norm and there'll be like a million farm stands throughout the valley. They're just a bunch of play structured amusement park farms. I'm not sure exactly how to police that though, or how to regulate it. I'm kind of going with the county on this.
Commissioner Lyman.
In 2001, the legislature amended the state land use law to allow promotional activities. And subsequently, the statute and rules adopted from that give a fair bit of discretion to farm operators to say what is a promotional activity. I think you can argue convincingly that a playground structure is a promotional activity. The challenge I've had with this one all along is the scale of the facility. We've all been to farm stands around the county and elsewhere, or maybe they have a swing set and a slide and nobody questions it. It's not a big deal. But the Packers have made an attractive playground, and we even had testimony from their supporters saying the primary reason they go there is the playground. That said, there's nothing in state law or rule that gives us guidance about can we regulate the size of the playground. So I have a hard time saying they can't have one, and I have a hard time saying how big it should be. But I share Commissioner Kitt's concern that if you get it to be the primary reason folks are going there, it becomes the cart before the horse. The playground should be there to support the kids learning about farm activity and maybe giving the parents a break while they're in shopping and farm stand.
Commissioner Garrett.
Jay, I think you did a great job of summarizing everything on this. I think that Josh, to answer your question, how do you prevent every farm from becoming a playground? I think the Packers have done a great job of saying it's going to. You're not reducing the size of it; you're reducing the temporal scale of it, and I think that's the impact that makes a difference. That's all I got.
My concern with the playground is the location. Location in proximity to the neighbor's house. I wish there was another location that we could move this to. I understand the promotional. That is a huge benefit to kids that don't come from farms or don't grow up on farms and don't understand agriculture to be able to do that. But I really wish that there was a better spot to put it than right next to the guy's house. So that's my take on it.
That's a tough one. I mean, that you could also make the argument the house is on EFU, right?
Sure.
Doesn't the tend to have residential homes there, and when you buy a house on EFU on a subdivided parcel, you take a risk that something farm adjacent could be there. It could be a trash pile, a burn pile. It could be dilapidated equipment, and I think that reducing the temporal scale of it goes a long ways to minimizing the impact of it, and especially it's if you're looking at October, the daylight hours where it's going to be used, it's not going to be going on at 9 o'clock at night. It's a reduced scope.
And generally speaking, it's weekend hours. I mean, from what we understand, their hours they're not open 7 days a week. Most kids are in school during the week, and then maybe they come after school, or I don't know, or on the weekends.
I'd like a motion to approve condition 11 is written by the applicant.
Okay, is there a second?
Second.
Okay, any other discussion? Commissioner Garrett,
Yes.
Commissioner Lyman,
Yes.
Commissioner Kitts. Yes. Commissioner Guisto,
Yes.
Commissioner Moore,
Yes.
Commissioner Loomis.
Yes.
The chair votes no.
With the other conditions besides the issue about admissions fees and incidentals having been changed by the commissioners and approved to the suggestions made by Packer Orchards, commissioners decided and moved that the staff will bring back a revised staff report with those remaining conditions approved as amended and bring it back for the review on March 11th for final approval. After that, Chair Von Luken was reelected as chair and Jay Lyman was elected as vice chair.